They said the empire was built on gold, and now the headlines say the stories unfold. Flashing lights, courtroom rows, silence loud, and the pressure grows. From Harlem streets to the Forbes list, now he's sitting where the storm hits. Cameras on, but who's legit? Truth and lies in the same script. Diddy defense team got 8 on the move. Agnafilo, Jarago, Shapiro, Steele, Donaldson, Westmoreland, Estavo and Driscoll. The feds got him on 5 charges. They say he on that RICO. Media says he is guilty out the gate. 8 male jurors and 4 women hold his fate. No cameras allowed in the court. Content creators screaming more, more, more. Diamonds heavy, but the weight's not cash. Every step watched through the media flash. Friends turn foes and the past don't pass. When receipts get pulled and they come in stacks. Official transcripts will show the full story. Full statements, but the details may be gold. They wanna put me on trial, put my name on file. Want me to hang it up, but that ain't my style. Say I'm back on road, no hand on Bible. We got this game in a chokehold. Yeah, I'm so cold. My whole career they tried to test me and I aced it. When you want something done, you gotta go and get it. Hate to put you on blast, but it's not up for debate. When the odds stacked against me, victims' names not being used to keep from getting approached by the accused. Kanye showing up in white, saying Diddy fight, fight. What's legacy when it's on the line? Is the name you built still gonna shine? Or does silence scream like a warning sign while the world debates guilt or crime? Every empire's got a tale untold. Every mogul's got nights cold. But behind closed doors, who holds control? Truth is a mirror and it never folds. Spotlight shadows can't outrun fate. Every crown's heavy when it's tied to the state. From the charts to the court, it's a razor blade. Walking the edge that the headlines made. Did the feds charge Diddy for his crimes, or just for some freak off good times? Baby oil galore, but the feds say there is much more. Everyone is innocent until proven guilty. This will be left to the 12 on the jury committee. Is this a RICO, or just a man being major sicko? Was he really the king or just a fling? Did Diddy do what they say? Will NYC jail be where he will stay? Did he bop in the hotels on the top floors? Different bows in different area codes. Some would call them the defense saying evidence is a blur. Some witnesses concur. Will the bad boy for life be serving life, or will he get the win and be in the next jet to Berlin? Spotlight shadows can't outrun fate. Every crown's heavy when it's tied to the state. From the charts to the court, it's a razor blade. Walking the edge that the headlines made. The devil is in the details. While the world debates guilt or crime, is it RICO or freak off?
Diddy says he is love, love, love.
They said the empire was built on gold, and now the headlines say the stories unfold. Flashing lights, courtroom rows, silence loud, and the pressure grows. From Harlem streets to the Forbes list, now he's sitting where the storm hits. Cameras on, but who's legit? Truth and lies in the same script. Diddy defense team got 8 on the move. Agnafilo, Jarago, Shapiro, Steele, Donaldson, Westmoreland, Estavo and Driscoll. The feds got him on 5 charges. They say he on that RICO. Media says he is guilty out the gate. 8 male jurors and 4 women hold his fate. No cameras allowed in the court. Content creators screaming more, more, more. Diamonds heavy.
Thank you, Inner Beauty. I'm sitting here just talking. Thank you, Serena. Can you guys hear me now? Can you 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 hear me now? I'm sitting here talking to you guys. Oh my God. Can you hear me now? Can you hear me now? Thank you, Inner Beauty. Thank you, thank you, thank you, thank you, thank you. I had it muted. I had it muted. I mean, I am just too much. What I was saying is, I have the transcript. You guys gonna get to hear my skills of being an actress. I'm gonna play all the different parts: the judge, the uh, attorney Shapiro, Slavic, and all. Oh, thank you so much for the. Oh, thank you, Mind Chaos Brew. I appreciate you for the love. Thank you so much. You know what? You just made my day today. Thank you, thank you, thank you. Because I don't be getting those kind of things. People don't love me like that, y'all. They don't love me. They just use me. But that's okay. God got me. But thank you for showing the love, Mind Chaos. I appreciate you so much. Shout out to you. May God bless you with 1,001,000,000% of what you have given to me. Thank you so much. But anyway, I'm going to play all these roles. I have the transcript, so I'm going to go ahead and be all of these people. Oh, Lord, y'all, look who just came in here to disturb me. Oh, she's not disturbing me, y'all. Okay, so say hi to the people. Okay, we're not gonna be bothered with Madison right now. We're just gonna do our own thing, okay? Bye, Maddie.
Hi guys, I'm here to give y'all a little
No, I got to read to the people.
text.
No, can we do our show later on? Go right. You see, I let you use my book. Go right. Go ahead.
Downstairs?
Yeah, go right downstairs. Yeah, and come back in about 2 hours. 2 hours. Okay, close the door. Close my door. Close my door.
Come on, you can close the door.
Yes, because it's gonna be loud out there. Thank you. Okay, y'all, we're gonna deal with Madison later on, so we'll never get finished with this reading. Okay, so here we go, y'all. We're gonna get started. Thank you again for the super chat. I appreciate you. All right, ready? All right, here we go. Good morning, Your Honor. Christy Slavic, Meredith Foster, Madison Meisler, Emily Johnson, and Mitzi Steiner for the United States. We're joined at the council table with paralegal specialist Shannon Baker. Good morning. Good morning, Your Honor. Alexandria Shapiro with Mr. Combs, along with Jason Drexel, Brian Steele, Nicole Westmoreland, Mark Acken. Y'all know I messed it up. His name Acfilio, Tinny Garagos, Xavier Donaldson, and our colleagues Christopher Johnson and Jonah Altman. All are also sitting in the front council table for Mr. Cohn. Good morning to you. Good morning, Mr. Combs. Good morning, Your Honor. Good morning, Judge. Well, we're here for arguments on the Rule 29 and Rule 33 motion filed by the defense. Ms. Slavic, you saw I can't even talk like him. Okay, Ms. Slavic, you saw the order with a few of questions that we had. Yes, Your Honor. I thought we'll just jump into those after we address these questions. I'm happy for each side to take some time to to address everything that they wanted. Ms. Shapiro, same for you, assuming that you're going to be arguing this for the defense? Yes, Your Honor. All right. The only thing I'll say is that you don't have to take the full 15 minutes. If you've or you've said everything that you needed to in the papers. In your papers. The briefs are excellent. They were comprehensive. They were very long. And so there's no need to rehash what's in the papers. But if there's anything that you left out or any new material that you wanted to bring to the court's attention, we should certainly do so. You should certainly do so. With that, Ms. Slavic, are you going to handle the argument? Your Honor, I think we're going to do a bit of tag teaming from the government side. So if you want to go in order of the questions, we're happy to do that. Ms. Foster will be handling two.
Watch your little sister.
Okay. Ms. Foster will be handling first two questions, and I'll be handling the second two questions. So however Your Honor wants it to proceed. All right. Ms. Foster, let's start with the question of waiver and forfeiture. So the defense says, looking at the three cases we cited in our order, that sure, there might be a forfeiture of Rule 33 argument challenging the jury's instruction. But under these three cases, at least you still can make a Rule 29 sufficiency argument based on a different construction that you presented at the jury instruction phase. Do you have a case that say otherwise? Gives this very recent Second Circuit proceedings? Yes, Your Honor. I would actually point the court to a case from earlier this year, which is United States versus Kelly. Y'all remember we said it, Kelly. United States versus Kelly. That 128 F 4th 387. And that's Second Circuit 2025. In that case, the defendant argued on appeal that one of the state statute that underlined his RICO and Mann Act conviction was unconstitutionally vague, both as applied and on its face. In that case, the court upheld the lower court's holding that the vagueness challenge was untimely and forfeited because it should have been raised in the Rule 12 motion. So, while this case didn't arise in the Rule 29 context, it clearly stands for the proposition which the government is making here. That arguments of statute construction that can be made pretrial, like those here, should be raised pretrial in Rule 12 motion or deemed forfeited. That case also cite in Second Circuit decision in United States versus Crowley, which is 236 F 3D 104, the Second Circuit from 2000. I would also just generally point the court to a different decision in Second Circuit in the different United States versus Crowley, which is 318 F3D 401, and that's on 2003. That's from 2003, as well as the Supreme Court's decision in David versus United States 411 US 23 from 1973. Those discuss these broader fairness concern that really underlines the government's position on waiver and forfeiture, and why it's so important that motions such as this be brought pre-trial. Oh Lord, the conversation, Lord lady, come on. As these cases explain, if claims that reasonably could be adjudicated and brought pretrial could be delayed until after conviction. then there would be no incentive for a defendant to raise those claims pretrial, because a defendant could just hold them in their back pocket in the event of hoping for an acquittal. And then in the event of conviction, that what happens here? What happened here? Raise those statutory argument as sort of a second bite at the apple. So, in addition to encouraging gamemanship, this just raised a host of fairness, efficiency, and justice concern. First, as a court has explained, it encouraged defendant to raise these claims after the witnesses, the parties, and the court. The jury has all gone through the length and burden of a lengthy trial, which occurred here. And I think this concern is particularly real here because essentially what the defendant is arguing is that he can raise for the first time after multi-months trial, and after he actually suggested definition of prostitution, which the court adopted, that actually that was the incorrect interpretation, and that basically essentially they're making the argument that trial, they sort of knew that this, and they had every basis for knowing that this definition and making the argument they make today based on the indictment. But they chose not to raise it until after the trial and after they have suggested a contrary definition to the court. Well, let's separate out the jury's instruction from the indictment. So kind of looking back in time and then looking forward in time. So I think the defense argument is, look, there are these three cases that say that the Rule 29 argument is not affected by any failure of object to jury's instruction. Let's put that on the side for a moment. We're saying that based on Kelly and these other cases, the type of constitutional challenge that the defense has raised, those are the type of arguments that you would have to make at the Rule 12 stage. And having not made those arguments, those are, I suppose, forfeited, right? That's correct, Your Honor. Oh, all right. And the defense response, yes, perhaps a facial challenge based on the defect in the indictment would, in fact, be forfeited based on the failure to raise that at the initial stage. But I understand defense to making an as applied argument as their constitutional issues. And so that is based on the evidence and that presented at trial. So the appropriate place to make the argument was Rule 29 stage. Ms. Foster. Well, Your Honor, in Kelly, that was also an as applied challenge. The decision in this circuit are clear that if an as-applied challenge can be made on the face of the indictment, the people regularly bring as-applied challenge where they can be brought pretrial. Then they should be brought in a Rule 12. And I don't understand the defendant why they say a line in their brief that they couldn't have brought this earlier. It's entirely unclear to me why they couldn't have, because in the lengthy speaking indictment, in this case, in the government's own representation of its evidence, and everyone's understanding of the evidence, in this case, there are never any allegation that the defendant, for example, financially profited from the prostitution here. And so this is a type of argument that could be brought pretrial and on the face of the indictment and could have been raised and resolved at that stage. I also do, though, want to push back on the idea that those three cases can be read as broadly as the defense would ask the court to read them. Okay? So, in that first case, Dennis, while the defendant sort of framed the argument as applied challenge to the constitutionality of the statute, the court found that he was essentially just raising a sufficiency argument. And that made sense because in that case, the defendant was arguing that he couldn't be tried under the statute without infringing on the First Amendment unless there was a finding that he made a true threat. And the government agreed. So both parties were in argument on what the relevant illegal principle were and what the court had to find in order to not infringe on the First Amendment. So the court in that case found that this was really just a sufficiency argument and that the defendant was making as to whether or not the evidence at trial even met the true threat standard. Well, the court could construe the statute in the context of the Rule 29 challenge. That's the first thing it did. And then it addressed the Rule 29 challenge without addressing any kind of waiver or forfeiture argument. Then it goes to the Rule 33 challenge in the instructions. And it very clearly says that the defendant had forfeited his challenge to the instruction because he didn't object to the broader construction of the statute at the jury instruction phase. So, how do you reconcile that? I would agree with that. The court goes on to hold that there does need to be a true threat in order for there to not be the First Amendment issue. But the court does, after that, it clearly states that this is an actual sufficiency argument. That while the government is claiming waiver, no one is disagreeing about a true threat has to be found. And so essentially, the only disagreement between the parties is whether or not the evidence was sufficient. The court then, I agree, goes on to a separate find. And I think at that point, it's one of the last circuits to sort of address that question. And so it does go on and address that issue. But it doesn't it's not going against either party's interpretation of the statute at that point. Understood. Going back to the initial point, it was Crowley, and there is another case that you had mentioned, Crowley and Dennis, which is a Supreme Court case. Those, I think, speak to the sort of equitable concern that the government is raising with respect to why the prejudice that the government has, the efficiency concern that arise when these type of arguments are made so late in the game. All right, understood. Ms. Shapiro, why don't you do this ping pong style? You want to address the cases and the argument that Ms. Forster made? Well, Your Honor. Sure, Your Honor. First, I just want to start by noting that Okay, she kept saying okay, y'all, because I gotta go do my okay? Y'all understand? Just mind your damn business and get the hell out of here, okay? You ain't gotta be in here. Get out. Don't come in here complaining. Get out. Get out. Let me get you out of here because you come in here. Get out of here. Look, let me tell y'all something. Y'all don't have to sit in here and listen to me role play or anything. If you come in here to criticize me, you need to go. Period. I'm not dealing with that. You should be grateful that I even got the transcript to even read it to you guys. Come in here complaining all the time. Complain. Where is my girl? They're coming here always complaining. Where's Coco? Coco? Every freaking time some bozo come in here and complain. And it's very upsetting. My skin is not thick right now. All right, y'all. Sorry about that. I just got a text. Where was I at before I was rudely interrupted by this comment? Where was I at? He asked Shapiro. Okay, she said. Okay, here comes Shapiro. Sure, Your Honor. First, I would just like to start with by noting that, as court's question indicate, the Dennis case is squarely on point in that there was a statutory argument based on constitutional provision. The defendant had waived the or failed to preserve the jury's instruction issue, but the court made very clear it was appropriate to raise that statutory construction, which was again based on the constitutional argument, as our arguments are here. And the court said that that's perfectly fine and can be raised at Rule 29. I also want to call the court's attention to the fact that, in addition to Macchio and Zaki, I don't know how to say that, which I think are very clear on their face and stand for the proposition that on Rule 29, the evidence is assessed in light of the element under the correct law, and also recent in the Lopez case in the Second Circuit, which we only briefly discussed in our motion, but which is cited there. That case was decided. And I believe during this trial and at the end, I think it's a date in July, and the government made the exact same argument in the Lopez case repeatedly, both in the district court level and in the Second Circuit. This issue was discussed at oral argument and the subject of the 28J letter. So, an oral argument, I made the point to the Second Circuit that sufficiency is not assessed based on the jury's instruction. It's assessed based on the correct law. The government filed a 28J letter in which it said the same thing. It says here about the M case. It said that case only applies when it's unnecessary. It's unnecessary element added to the jury charge. Our response that's at docket 113 of the Lopez case, which is cited in our briefs. Our response in which docket 114 made the exact same point we're making now, which is that's wrong on Rule 29. The factual sufficiency is assessed against the correct law, regardless of what was in the jury instruction. I would also note that in Lopez, there was a dispute about whether a constitutional vagueness argument that had been raised in the pretrial motion was sufficient. But again, all of that is irrelevant because you have pretrial motions. You have Rule 30, jury instructions proceeding, and you have Rule 29. If you raise something on Rule 12 and the judge doesn't dismiss the indictment, the remedy on appeal, if you win the appeal, you make an argument it should have been dismissed. The indictment is dismissed. That doesn't lead to an acquittal. The same thing with jury instruction. The remedy is a new trial. And moreover, the law on Rule 12, as the government well knows, is extremely restrictive. And there's tons and tons of cases, some of which we cited in our brief. We only addressed this briefly in the reply brief. I believe establishing that all the government has to do, and they say this in their brief, in every case, is parroted the language of statute. They clearly had done that here. I would also add that, particularly with respect to our First Amendment argument, there is no way we have made the argument at an early point because the government had charged sex trafficking and RICO, and we're not arguing, nor could we, that anyone has a First Amendment right to film a live performance of a crime. So it's only as a result of the acquittal that we're even able to make that argument based on the record at trial. So your point is that, look, let me just make sure I understand. The constitutional argument that you're making, vagueness, fundamentalism, substantive due process, and the First Amendment argument, those are as applied challenges, right? Correct. So your point is we're not challenging the indictment. We're saying that based on the evidence presented during this trial, that what's gives rise to the constitutional challenge that we're making. And so the appropriate place for us to raise those challenges is in the context of Rule 29. And your argument is at all times against challenging the sufficiency of the evidence? Is just challenging the sufficiency of the evidence in light of the relevant statutory construction that you say applies and the relevant constitutional principle? So your point is this where we make that because we think that based on those sources of law, we are entitled to an acquittal? Exactly, Your Honor. Okay. The last thing I'll say is I haven't had a chance to fully read those cases, but as the government conceded in its explanation, the Kelly's case is not in Rule 29 context at all. So it's irrelevant to this issue and certainly doesn't control when we have other Second Circuit cases on point. I also want to mention that the Solo case, which we cited in our reply brief, which is just the example of the many times that appellate court reviews satisfactory argument in the context of Rule 29 or sufficiency claim, also was case where the defendant didn't object to the charges. That's not mentioned in the opinion. But in the Eastern District docket number 10 CR 708, docket number 136 at 4, you can see that the government pointed out that the defendant had raised this statutory argument for the first time in Rule 29. The Davis case, which I haven't had a chance to reread, but it's a 2255 case, so I expect it's entirely irrelevant because there are various procedural bars that applies to collateral relief claims, and we are happy if the court would like us to study those cases and respond. But I think clearly none of them, and Davis was a claim of grand jury discrimination. I'm told by Mr. Drexel. Okay, well, we'll take a look at those cases. Why don't we move to the second question, and maybe Ms. Shapiro, I'll start with you. So you have two statutory construction argument that you've made. First is that the defendant in a Mann Act prosecution has to have at least a financial motive, and second, that there has to be a bilateral exchange of money and sex. That's part of parcel with the definition of prostitution. So I take it that you give those two. Well, let me first ask you, are those alternative requirement, or do they have to exist in all cases together? No, those alternative arguments are our argument that the statute should be construed narrowly, essentially to only apply to pimping, commercial privateer, and of prostitution. Or in the alternative, at the very least, it can't be applied to this particular situation. Not only because Mr. Combs was merely an alleged consumer, but because this is a wire type of case. All right. So if there is an alternative requirement, then let's put the financial motive part of it to the side because that involves Mr. Combs specifically. But as to the other part of it, why wouldn't Mr. Combs be liable under at the least a willfully causing theory, because at least in some of these instances, either Miss Ventura or Jane furnished the payment for the sex that occurred with the escort. So wouldn't the facts here support a conviction on a willfully causing theory if Mr. Cohn had the relevant intent and the required intent as we instructed the jury, and then the action were performed by Miss Ventura, Jane, and the escort? That would correspond to the bilateral exchange of money and sex. No, Your Honor. And there are several reasons for that. First of all, and sort of most fundamental, the part in these cases that we cited where a number of statutes have held that prostitution only involves an exchange between A and B, and where A is paying B to have sex with A. The purpose of that would be entirely defeated if the government could get around that with any theory of secondary liability. For an instance, some of those cases involve things like a person at a booth who's watching one or more people engaging in sexual activity, but not touching the person who's watching. And those cases are very clear that in those states, those courts are saying that it is not prostitution. The Mann Act, the statute, the actual res of the Mann Act is the transportation. And certainly the government's theory, presumably, that about transportation is that somebody else was doing the transport, but it was at Mr. Combs' direction. But the other part of the crime is the menace rea, the intent that the transportation will result in people engaging in prostitution. If we're right that prostitution doesn't include commercial voyeurism, I'll call it, and that's the term that some of the cases use. Then we can't say that he's willfully causing that, because then there's no point to the rule at all. The idea is that in the defendant's head about his understanding of engaging in prostitution, and if his understanding of engaging in prostitution is that it has to be narrowed to avoid a situation where we're not including conducts that a number of states have said is not prostitution, then you can't get around that by just saying that here it was two other people and he was paying, because that's exactly the situation in these other cases, like for example the Wooten case in California, and just the way the issue is articulated in a number of these cases. Okay, so while we're on that subject, on the bilateral exchange of money for sex, you mentioned Wooten. What other case is your? So there are a number of cases. So Polio Polino case in New York. Okay. There's also the Green case in New York. And in addition, there's a Georgia case which we cite in our opening brief. I can't remember the name of it. And there is a Pennsylvania case. Those are a few examples, but there are many state court cases that have held. The Georgia case involved a situation in which the government have alleged that a private resident was being used for prostitution, and the court held that the evidence didn't support that because there was no direct evidence of exactly what was going on in the residence, and that it could as easily have been commercial voyeurism, which could not qualify as prostitution. That one is called Smoot versus State. It's cited on page 21 to 22 of our opening brief. Yes. Switching gears, then we'll come back to Miss Foster. In financial motive, what's the case that we should look at? Shapiro? So, on financial motive, sorry, are you asking about aiding and abetting? Because I think it's clear that no, I heard you on the underlying reason. Why shouldn't why you shouldn't allow the government to approach this from a secondary liability perspective. And but now I'm going back to the actual statutory interpretation argument. So you've mentioned the case that support the definition of would include bilateral exchange of money for sex. What about the defendant having a financial motive? Is that just a pure constitutional avoidance issue? Or is there it's a constitutional avoidance issue. And just to be clear, I think I'll get to that in a second. But if I may, but in addition, other points that are the statute originally had this explicit text referring to immoral purposes and debauchery, which was exercised in 1986. After Cleveland and Cananiti, there is there was a subsequent very short summary order by Supreme Court in which the court reversed the Seventh Circuit holding affirming, which had affirmed a conviction there where the defendant didn't have commercial motive. And then, of course, we have this constitutional point. And one of the points I wanted to emphasize there is, if I may, is that if you look at the Cleveland and Calamity cases, there were clear that the court is saying the word prostitution, even those words were in the statute, including sex for hire, and not for hire when it's for immoral purposes, like traveling interstate for a woman to be a mistress or a concubine, for example, or in the case of the Cleveland case, polygamy. In the court is very clear that it doesn't matter if it's for hire. But then, just to push back a little bit, there's in Calamity. Is it true the court said that prostitution can be for hire or not for hire? But Cleveland said the opposite. That at least as of 1946, the definition was sex for hire. In that case, the court held that polygamy would fall under immoral purpose clause. So, for that reason, the court sustained the conviction in that case. But prostitution wasn't an issue in that case because it was not part of the statute that the court was looking at. It was instead looking at the debauchery of immoral purposes clause. Your Honor, respectively, I disagree with that because there's a passage in the opinion in which the court discusses, in quotes, the Biddy case, which is what that case from the late 19th century involving a similarly wordy immigration statute. And the court quote the part of Biddy that talks about how the word prostitution includes sexual relations for hire and not for hire. So, respectively, I think Cleveland has been cited by the government here and by the government and courts in many other cases for the proposition that the statute is not limited to commercial purpose. Right. Because at that time, the statute was not limited to commercial purposes because the language was different. It was changed in 1986 amendment. But as of the time of Cleveland, the statute had a bunch of other language in there that would cover non-commercial transaction. That was the point that the court was making in Cleveland, because it it points out right after the citation that you pointed out to, that it had no view on whether the Clemente case came out rightly or wrongly. But the court noted that because of the broad language of debauchery and immoral purpose, the statute was not limited to commercial transaction and could include a broader sweep that would include things like, at that time, polygamy, and that is where Cleveland left it. And you have the 1986 amendment, which obviously strips out the other language. In fact, it strikes the entire statutory text and replaced it with language that has prostitution and the criminal violation language that is in the present statute. As of that time, I think anyone's questioning that the settled meaning of prostitution as sex for hire, right? So at that time, Congress looked at it and they had the language from Cleveland, where Cleveland itself said that prostitution means sex for hire. And then in 1986, they redacted the language with prostitution, stripping out that broader language that the Cleveland court had relied on in sustaining the conviction in that case. Well, I guess I don't know that really matters here. I don't know that that's a problem for us. Anything, Your Honor, anything Your Honor is saying, it's all consistent with our argument here. I don't necessarily disagree with you, because I think you're making two further arguments that are based on the statute authority of Polino, Wooten, Freeman, and these other cases that were cited. So I think that's an independent issue. Right. So now, with that background as to financial motive, the other thing I was going to say was that the judge says, I just want to make sure I'm getting your best cases. So on the defendant having to have a financial motive, I take it that your answer was, well, after Cleveland, there was a summary order that dealt with by the Supreme Court of the United States. Right. That dealt with the Seventh Circuit that can only be read to require defendant in one of these cases to have a financial motive. That's correct, Your Honor. Okay, I'll take a look at that. Shapiro says, the only other thing I'll say, and I understand that what Your Honor said about Cleveland, but I think it's important to understand that when you look at Caminiti, which apart from the debate about Cleveland, clearly it is saying that the word prostitution does not require sex for hire. When we know that holding is not good law because of Griswold and its prodigy, including Lawrence, leading up to Lawrence versus Texas, and all the federal constitutional law that developed afterwards about people's freedom and the right to privacy to engage in essentially, as long as they're consenting adults, sexual relationship in whatever way they see fit. Understood. Miss Foster? So going back to the question that we started with, which is, given what Miss Shapiro's just said, is the government going to concede that? Yeah, we raised the issue about secondary liability, but we don't think you should adopt the defense construction of the statute. If you were to adopt that construction, then I suppose it could come. The aiding and abetting and willfully causing conviction would rise and fall with the main liability. Or do you have a way in which those theories would be nevertheless be grounds to sustain the conviction? Yes, Your Honor. So I think your question gets at something that really distinguishes this case in a lot of ways from some of the cases that the defendant is raising, such as the one where a person at a booth watches two individuals engage in sexual relationship, and which shows that I would say even under primary liability, even if the court were to adopt their definition, the defendant's conviction would still stand. That's because what the defendant really appears to be challenging is the vagueness and the interpretation of the term prostitution. My understanding of their argument is that that term, based on sort of case law and definition, is overboard and should be interpreted in only the specific situation. One where the person who engages in sexual contact with escort is the person who's paying the escort. And two, where a person has financial motive. Here, the defendant seems to be arguing because the defendant wasn't involved in the sexual contact with the escort that he's not guilty. But the issue in front of this court, and they made this point with the actus reus, the issue before the court is not whether the defendant himself engaged in prostitution, is whether there's sufficient evidence from which this court could find that the defendant knowingly transported an individual with the intent that the person would engage in prostitution. And here, even in a world where the defendant wasn't engaged in and involved in those acts of prostitution himself, there was clearly sufficient evidence for the reason you mentioned, from which a jury could convict under the Mann Act, even under this definition, with constrained definition of prostitution that the defendant seemed to be arguing for, because there is evidence in the record, as Your Honor noted, even though the defendant was the one who ultimately funded these acts, the victims and the one who actually engaged in the sexual intercourse with the escort, were the ones who handed over the money in large majority of the cases. So when the defendant, even under primary liability standpoint, when he would facilitate transportation, a reasonable juror could conclude based on that evidence that he was doing so with the intent that prostitution. Even under that narrow definition, they are arguing for occurred, which is that the victims, the people who turned over the cash, were the people who had sexual intercourse. So I think even if the court were to adopt their interpretation of prostitution, which is sort of separate from ours, where the person who engaged in the intercourse doesn't have to be the same person who turned over the money, the defendant would still be liable under primary liability, even under their definition, based on the evidence at trial. And I think there was more than sufficient evidence of that. But the defendant at times in their argument sort of seem to have second step, which is like actually the person who transport also needs to have had some involvement in that prostitution, which I'm not quite sure how they can get there. But in that case, Your Honor is correct that secondary liability would seem to solve that issue, because there's no doubt that the evidence showed that in many cases, the victims here, the women, facilitated the transportation of these escorts. They would help arrange the tickets. They would pay for the transportation of the individuals. They would set up the flight, and the defendant, let me just make sure I understand your argument about primary liability. You're saying on a, I suppose it would be a, would it be a willfully causing theory? Yeah, or aiding and abetting. But you're saying that Miss Ventura and Jane, they did the transporting, so they did that. They may not have had the relevant intent, or you're maybe you're saying they did? Well, I think they have, because as they both testified, they stood understood that they were turning over money, and they were doing it for the service of prostitution. And a reasonable jury could have determined that. So you're saying that they had all this intent, and they did the acts, and they paid the money, and they had sex. Yes. And that would meet the defense construction of statute, right? That's correct. And the defendant clearly, the evidence would suggest aiding and abetted, or willfully caused that by being the person who suggested it, was the ultimate source of payment, had his own staff oftentimes arrange travel and book travel. So I think of in sum, none of their Rule 29 argument actually on the statutory construction may actually matter that much in light of the evidence and the standard that the court had to apply in adjudicating a Rule 29 motion, which is to see whether there is any evidence from which a reasonable juror could find the defendant guilty. All right, very good. So, Ms. Shapiro, Your Honor, may I respond very briefly to that? You know, that might make sense, since I'm going to give each side a chance to come back at the end. You can pick it up at the closing, just so that we can get through these questions at the beginning. So, Ms. Slavic? Yes, Your Honor. I'll respond to the second two question related to First Amendment argument. If Your Honor would permit me, may I answer the fourth question first? Kind of go out of order? Yes, that's fine. So, the fourth question was about whether the record shows that every time an escort traveled across state lines, it was filmed. And I just started by answering the question directly. The answer to that question is no. The record does not show that every time an escort traveled internationally or domestically and had sex, that that act was filmed. To be clear, I don't understand the defendant being argued with the defendant to be arguing that. I think it I think in the reply brief, the defense says that escorts were routinely filmed. It doesn't say that they were always filmed every time they crossed state lines. The record surely does not support the inference that every time an escort traveled, the sex act was filmed by the defendant. We note in our opposition brief that the evidence at trial reflect that the defendant frequently filmed freak-offs or hotel nights, but he did not do so all the time. The evidence, of course, includes the testimony of both Cassie and Miss Ventura and Jane. Why is it three people? Why is it Cassie, Miss Ventura, and Jane? So it's two Miss Ventura. I thought Cassie was Miss Ventura. Okay, sorry. As well as the two escort that testify at trial. But the two summary exhibit at government's exhibit 1402 and 1406, I think could be helpful to the court. Those exhibits show examples of freak offs in case of Miss Ventura or hotel night in case of Jane. It's not an exhaustive list, as I think was made clear at trial, but it's a list of certain freak offs and hotel nights. And those exhibits show travel records, and they were available, and they also indicate instances when in which there were explicit videos and explicit photos recovered by the government. Those are any reference to the X series. Those are the explicit videos and content. So, what those charts shows is that on many occasions there were travel for freak offs or hotel nights, whether it was Miss Ventura, whether it was Jane, whether it was a male escort, but there were no videos or photos recovered from those specific encounters. I'm happy to go through. We can pull those exhibit if your honor would find it helpful, but I think your second argument is even if it was the case that every one of these incidents was filmed, that would make a difference under the relevant. That's actually right. So let me go to the second part of your question, which is, does this matter? And I think the answer is no, because there is threshold question that's just make all of this irrelevant. And that is whether we should even talk about the First Amendment here. Just focusing on the Mann Act, the counts of conviction. The Mann Act criminalizes transportation of individual for the purpose of prostitution. It does not criminalize film and sex acts of any kind. It criminalizes transportation. As Ms. Shapiro just said, the actual reus is transportation. Transportation for prostitution is obviously not pure speech. So the question is then, is it symbolic speech? I think it laid out the in the papers. The test to determine whether something is symbolic speech or is examining whether there is an intent to convey a message and whether that message is likely to be understood. That's the Spence case from the Supreme Court. And the conduct here, transporting individual to engage in prostitution, that just cannot be understood to convey a message, much less a message that could be understood. So I think what that means is that there is no symbolic speech, and O'Brien doesn't even apply. Looking at the fact that in O'Brien, I think is helpful because in O'Brien, the law at issue is that there was related to the destruction of draft cards, and the protected speech was burning in the draft cards. So, in other words, the protected symbolic speech was the very act that violated the law. Here, the act that violated the law was transportation, which is not symbolic speech, protected symbolic speech. I would point your honor to, so you're telling me that, let's say you had a movie producer who's making pornography, and he transport actors across state lines for the purpose of making pornographic sorry, films where he would have sex for money. In that circumstance, are you saying First Amendment is not implicated? Because I think that some of the cases that Ms. Superior has pointed out to map that scenario. I think, Your Honor, it would be closer call. I think the Roeder case from the 11th Circuit touches on those cases. The fact in this case are nowhere near the facts of Roeder. In Roeder, the defendant transported a woman across state line for the purpose of prostitution, but also for the purpose of filming the movie. And the record in that case indicates that the defendant told the woman as he was transporting her across state line, we'll be filming a movie. That is absolutely not the case here. The record certainly does not support that sort of inference. The record here support that when the defendant transported the individuals across state lines, which is the moment that we need to look at for the Mann Act, he intended for those individuals to engage in prostitution. Nothing more than that. And I think that's where Your Honor's question about was this film all the time? That is relevant because it is just not the case that the defendant was an amateur porn producer. That's not the case here. Right. So it's an as applied challenge to back up. You're not saying that there's might never be a case where a Mann Act prosecution would raise First Amendment concern. It might, it's just not in this case. In this case, in fact, to Freeman, there is Lord, those other cases cited by the defendant, there was a motive. Jury could easily find that the intent of the transportation was prostitution. And in fact, that's what the jury found by convicting him of Mann Act counts. Yes, that's right, Your Honor. Okay. So I'll be happy to continue to explain O'Brien does not apply. I can also happily go to your third question, which was whether O'Brien applies or not. However, Your Honor, would like to take it. Well, let's go to. I've heard you say on why we never get to O'Brien. So why don't you move to O'Brien, and why, in this context, is the government's interest important and no more than essential to satisfy that interest? Slavic, Your Honor. Yes, Your Honor. So the question of whether there is an important governmental interest, courts that have addressed laws regarding prostitution have uniformly concluded that there is a substantial government interest in regulating prostitution. I have not found any case to the contrary. One case to point, Your Honor, towards the Arcara and Cloud Books case. It's a 1986 case. There's kind of 2 points on that case. The first is, in that case, in the Cloud Books case, the court declined to apply O'Brien because, as I just mentioned, the act that was criminalized has nothing to do with expressive speech. So I point, Your Honor, to that case for the proposition, but also for the proposition that regulating prostitution is a governmental interest. That case addressed a New York statute that was related to prostitution. It was about closing down buildings where prostitution took place. And it wasn't even a question that regulating prostitution was an important government interest. Even the dissenting opinion, I think it was Justice Sorter dissent that would have applied the O'Brien test, which is not what the majority decided. Even Justice Sauter agreed that the state interest in regulating prostitution is important or substantial under the O'Brien test. There is also a line of Supreme Court cases that addresses public decency law and their effects on nude dancing. In those cases, the court have repeatedly found that these sort of general law prohibiting public nudity promotes the state's important interest in preventing secondary effects on adult entertainment establishment, including prostitution, sexual assault, and other sort of criminal activity. So I think there's a related question. So that's all the answer. Is there an important or substantial government interest? Your Honor's question that said why. And I think the answer to that is that regulating prostitution is important because it can include discouraging violence against women, discouraging illegal drug use. There are public health reasons for preventing diseases. These reasons are laid out in the Ninth Circuit opinion called Erotic Service, provided legal education and research project. And that the Ninth Circuit 2018 case that challenged a law criminalizing prostitution in California. All of those things that answers the why the government might want to regulate prostitution, discouraging violence against women, preventing sexual assault, monitoring illegal drug use. All of those things are present here in this case. So, I think there is an important and substantial interest, and this federal interest is very consistent with the approach of other jurisdictions. All 50 states have law regulating prostitution. Some are vary in severity, but all have laws that regulate prostitution. So, what that means is that all 50 states have determined that there is a substantial state interest in thwarting prostitution, and courts have uniformly agreed that with that. And here in federal court, when interstate and international travel is concerned, then that's when the federal government has interest. So, the second part of your question is if regulating prostitution is an important government interest, and are the Mann Act's prohibition no more than essential to achieving that interest? And I think here the answer is yes. The government interest in thwarting prostitution, so the statutory provision is kind of the end in itself. The goal is to thwart prostitution, and so prohibiting the transportation of individuals to engage in prostitution is really the only way that the goal of thwarting prostitution could be accomplished. You ask for cases that support that proposition, I would point you to O'Brien case. That's the case that lays out the 4 factors. There, the court decide that the government's interests and the law at issue is limited to non-communicative aspect of the defendant's conduct, and therefore it satisfies the 4 prong of the O'Brien test. There is a case in the line of this public decency law case line that I just mentioned, Barnes versus Glenn Theater, and the effectively that effectively held that the government interest was the preservation of nudity in public places. And so the requirement that dancers wear panties and G-strings, that was really the only way that they could be accomplished. The only thing I'll note, in addition to the cases that I just raised, is that go back to Roeder's case, which, as I mentioned, did apply to O'Brien factors in a bit of perfunctory way. It wasn't like a full analysis, but it found that the Mann Act passed the O'Brien test when the defendant transported a woman across state lines, even where at the time of transportation he intended to film the sexual encounter. Judge, what was the name of the case? That was Roeder's case. I believe I said the 11th Circuit. It's actually the 10th Circuit. And the O'Brien analysis proceeds on an as applied basis, right? That's right, Your Honor. Thank you. Ms. Shapiro, I'll let you respond to the First Amendment writ large. And specifically, the question was about the O'Brien factor. But Ms. Slavic started with the threshold question of whether the First Amendment applies here at all. Yeah, so let me start with that. First of all, I agree with Ms. Slavic that our argument was not that. And to be clear, was not that Mr. Cohn film was always filmed, but it was routinely filmed. And there was evidence that it was probably filmed the vast majority of the time. For example, Jane testified that Combs filmed hotel nights almost every time. And even though there are some examples of the government's chart where they didn't introduce videos or photos, that doesn't mean that those particular events were not photographed. It just means that either the data no longer was on the no longer on the device, or the government chose not to introduce them. But the bigger point is that in our view, we also think it doesn't matter whether he always filmed them or not. We have two different First Amendment argument here. I will point out the government's entirely ignored the second one. I'll talk about the first one, which they did brief and discuss with our honor today, which is that he was a producer of amateur porn. But we have a secondary theory that he was a consumer of amateur porn, which I'll get into a minute. With respect with the producer element, I think it's well settled that this type of amateur porn, whether it's live or recorded, is protected by First Amendment. There was a lot of evidence in the case, some of which was greatly emphasized by the government during the trial and before the trial, about how highly choreographic these freak-offs and hotel nights were. The fact that there was mood lighting, there were costume indeed, as the court will recall. Both Miss Ventura and I believe Jane also testified the role playing, and Miss Ventura talked about in some of the early freak-offs wearing wigs and other costume. So it's clear from the case, like Freeman and T, that there were that where you have a person filming this type of thing, that is protected by First Amendment. But We also have cases, including some cited by my colleague on the other side, like the Glenn case and many other cases about new dancing and so forth, that this is protected whether it's live performance or not. Now, I want to talk a little bit about our point that Mr. Cohn had a right as a consumer. There are many cases on this. And most recent, which is cited in our paper in the Free Speech Coalition and Paxson's case, which reaffirms that adults have a right to consume pornography, a First Amendment right. And here we have not just Mr. Combs, but his girlfriends were also watching the ones that were filmed. Even Jane bought a TV so that they would watch movie nights together. And the government doesn't seem to have any response to that. I would point out, what does that have to do? This is the judge saying. What does that have to do with the count of conviction? The transportation was the purpose of Miss Ventura and Jane and the escort to engage in prostitution, that is, sex for hire. The mere fact that they videotaped those incidents and then they have consumed them later, how does that give rise to the First Amendment issue? Well, right. Because just to use the example of Freeman and T, right, in those two cases, there were no evidence, and the court made that very clear that the purpose of the actual sexual act for the gratification of a person taking the video or the participant. Instead, the cases proceeded on the basis that the purpose was the filming. And so then a First Amendment issue was brought to bear. But here, the government is saying that this was sex for hire. It was not performance for hire. And the jury couldn't easily determine that based on the fact in the records. Ms. Shapiro. Actually, in Freeman, there were alternative holding, and the court was quite clear that even if the evidence supported the notion that the person doing the filming had a motive for sexual gratification, that it would still be protected by the First Amendment. That's explicitly stated in Freeman. So I do not think that's right. In addition, the point that I'm making about consumption doesn't even require it to be recording a recorded film. So, for instance, OnlyFans came up in the trial. My understanding is that with respect to OnlyFans, that if it's often simply to live stream back and forth where two people are or somebody's watching someone on a camera that is not recorded. It's just happening in real time. So it doesn't really even matter, but I'm just pointing out that I think if the intent includes filming and watching later, that's part of overall point here that the judge says, you're saying that any prosecution for prostitution is defeated by the participant recording and then viewing the act at a later time. That's not what I'm saying. That's not what the court would need to hold to agree with this point. The point is that there are two different rights at issue here. And one of them is the right to watch porn. And that includes live porn, not just film porn. You might have a different case if you didn't have these highly orchestrated, highly choreographed performance involving what the government's witnesses call painting a sexy scene or so forth. So I think this argument is very particular with the specific facts of this case and the way in which the sexual activity was described by the government, its own witness, and as evidence by the video that are in evidence. In respect to the to the court's third question, so obviously, for all those reasons, we think it is clearly expressive conduct protected by the First Amendment. We conceded that we're in O'Brien, but there is no important government interest. And indeed, DOJ policy itself confirms as much because DOJ's policy for the last 75 years has been that the government does not prosecute Mann Act cases unless they involve a preserver, someone who's running a commercial business for exploiting sex workers. And then, a little bit after that policy was promulgated guarded in 1953, the government then began to add emphasis on cases involving minors and other sex trafficking. But we don't have any of that here. What we're left with after the jury's verdict is simply a case in which we have accepted that what we're talking about is consenting adults. There is no substantial or important government interest. And indeed, what some of the case talk about in connection with why regulating prostitution is an essential interest is secondary effect. So, for instance, crime will go up in neighborhoods where there is a massage parlor that are being used as house of prostitution or the like, that sort of thing. And here you don't have that concern because what we're talking about is occurring in the privacy of a hotel room or someone's residence. So there is no cases that I wanted to emphasize to the court in this regard. The first one is Texas versus Johnson, which is cited in our brief. And we understand that that case is a strict scrutiny case. It doesn't apply that O'Brien test. But the reason I think it's important is because it makes clear that when a challenge like this is brought, the question is not whether the state has sufficiency important interest sort of interest. I lost my spot. Sufficiency interest sort of in general in regulating the conduct. The question is whether the state's interest is sufficient, substantial, or important as it relates to a particular conduct of the defendant. So in Texas versus Johnson, one of the arguments Texas made was that it had an interest in preventing breach of the peace. That was the flag burning case. But the court held that Texas had failed to show that Johnson's conduct would likely result, particularly conduct like would likely result in a breach of the peace. The court wasn't denying that could be important interest in some sort case, but in the particular case of Johnson, the evidence was not sufficient. And that's what we have here. Accepting the jury's verdict. There's really no substantial interest in regulating private consensual sexual activity, which is, as I mentioned earlier, protected by the United States Constitution. Well, most prostitution in between consenting at all times in this sense that you're discussing. And I took Ms. Slavic to be saying that even under those circumstances, the court are uniform that the government has important interest in regulating that for the reason that it could be associated with other activity that the government would have an interest in policing. Sorry. That's perhaps even amplified when you're talking about the actual reyes here, which is the transportation of other people across state line, which might be connected to all sort of different illegal conduct. But it was focused on what's happening here, which is prostitution, without talking about non-consenting or coercion or anything like that. But no, but I think the point of Texas is that the government has to show, and there are other cases like this, but I mentioned that because it's a United States Supreme Court case, and it's not that long ago. And the point is that you have to look at the particular conduct of this defendant and not sort of generally. Another case. The judge says Miss Slavic referred to Miss Slavic and Miss Slavic and Miss Slavic referred to the fact that this case she pointed for an instant to illegal drug use as being one of the things that the evidence in this case showed. And that would be one of those things that the government would have an interest in policing, which is associated with prostitution, even if that's between consenting adults. Miss Shapiro says, well, I think the only drug charge that was brought in this case was in connection with the RICO charge, which Mr. Cohn was acquitted of. And as we discussed at a length in the jury charge conference, and as Mr. Agnifilio argued in the jury, is different when you're talking about personal use. So I think that it's sufficient here. And I think that this is the reason that DOJ policy doesn't even say what Miss Slavic said. DOJ policy specifically says that the statute should only be used against people who are running a business of prostitution or people who are exploiting minors or sex trafficking. The other case I wanted to cite, which is not in our paper, is a case called Whitewater Amusement Publishing Inc. versus Town of Hartsville, which is a Second Circuit case from 2007. That case involves an adult entertainment business which offered nude dancing, and it involves challenges to a town ordinance forbidding nudity and sex in a public place. The Second Circuit ruled that the town had failed to present an important or substantial interest for the ordinance. In that case, the town was claiming that there were secondary effects, as in Barn versus Glen Theater and Erie, and the Supreme Court nude dancing case and made argument along the lines of some of the things Miss Slavic was saying about other crimes and decreasing property values in that case. And the court said that might be a legitimate interest if there's evidence to support it. But here, there's no evidence to show that was really the purpose of it. I think that case is important because it shows that you really have to look at the evidence in a particular case. And I think the DOJ's policy itself is really what speaks volume to what the government is interested is here. And that is not. The judge says, thank you very much, Miss Slavic. Just one additional question. Are you aware of any cases, any Mann Act cases, where the transporter, the defendant, did not have, or the very least, a financial motive? I think the government cited the Me So Chu case, and I don't think the Second Circuit in that case referred to any financial motive on the part of the defendant. But I think if you look at the district court record, the defendant actually had been paid for the transportation of the individual from Atlantic City into New York. Is there another case there was no financial motive? Ms. Slavic says. In other words, John cases, Your Honor? Yes, Your Honor. The government is aware of other cases. I don't have any of them at my fingertip. I don't have any of them at my fingertip, but we plan to raise them in our sentencing summary, certainly. You see this? She didn't have it, but she said she's going to bring it up in her sentencing summary. So that means that the judge was going to deny this. That's because she said she's going to give it. Okay, let me shut up. In those cases, the person did the transporting actually for the I'm sorry. In those cases, what the judge saying. In those cases, the person did the transporting actually was a participant in the sexual activity. Slavic said, that's right. And then the judge says, do you have any case that involved a transporter who was transporting separate people but did not have financial motive? You understand what I'm saying? Oh my God. And then she says, not really. Then he says, so a person A transport person B to have sex with person C. All right. So they doing the transporting, the other elements are satisfied. They don't have financial motive, but they are nevertheless prosecuted and convicted under Mann Act. Then she says, I understand, Your Honor. Then she says, yes, we do have example. Again, I think that will refer those in our sentencing summary as well. See, she's still not prepared, y'all, and she's bringing it to the sentencing summary. So she's trying to say the judge is going to deny it. Okay. Then the judge said, all right, very good. Those are my question. Then he says, Miss Shapiro, I'm happy to give you the first chance, and there anything you want to address that we didn't cover today that you want to spend some time on? You don't have to, but the floor is yours. Then Ms. Shapiro says, Your Honor, first, I did want to just respond to one thing Ms. Foster said at the end of the discussion of the second question with respect to secondary liability. I just wanted to make a few points in response to that. First, so I think she said that Mr. Cohn was paying and that there were instances in which Miss Ventura or Miss Jane would hand money to the mail. And I think it's undisputed that the money was Mr. Cohn's money. And if that would be sufficient, then, for instance, let's take the case of Wooten. That's one of the cases with the booths. If a person paying to watch the people have sex had given his cash to somebody else who worked in the establishment, who in turn gave it to the performers, then we would say, oh, the result has to be different. But that doesn't make it any sense. That doesn't make any sense. The point here is that the money is coming from Mr. Cohn. The fact that somebody else may have or some occasion been the one to hand the money to hand it to the male doesn't change the analysis. And indeed, that's why the government has, throughout this case itself, argued that Mr. Cohn was the ringmaster here, even on page 1 of the opposition to this motion. They referred to him as the mastermind. They said he transported, he directed. They never raised the aiding and abetting or secondary liability theory to the jury in any way. And I think that just speaks volume to what we're really talking about here. The other thing I want to mention with respect to that was that I believe Miss Forcer said that 2 women testified that they were paying for prostitution. And maybe they were at a different trial than I was at. But I don't believe either of them said that they were ever suggested that they were involved in prostitution or used the word in that way. So I want to be clear. I want that to be clear. This was not consistent with the record. The last thing I just wanted, the judge says, just so I'm clear, let me give you an example. This comes out of Freeman's case. A businessman and a client goes to a brothel. This is an example given in the case, okay? The businessman pays the brothel for a prostitute to have sex with his or her client. You're saying that's not prostitution? Shapiro said, correct. I mean, assuming in the business man is a voyeur. No, he's just trying to curry flavor with his client through prostitution. Otherwise, prostitution transaction, this is an example given. And then Shapiro said, I see. And the judge said, you understand what I'm saying? And then Shapiro said, I might be in a different case. Then the judge said, why would that be different case? So a businessman has no financial motive other than Shapiro said, because he's not a voyeur. So we're making 2 arguments. One is the financial motive. I assume you're putting that to one side and saying, assuming you reject that argument, then we're talking. And the judge says, I'm talking both of them. I'm saying the businessman has no financial motive in the prostitution transaction. He's just with his client, and he is doing the paying and not the client, who is engaging in sex with the prostitute. That's a factual scenario that came up in the Wisconsin case. Excuse me. Sorry. Excuse me. Hold on. One more. I feel a sneeze coming on, but it's not coming. Sorry, y'all. Allergies. Hold on. I feel it coming. Oh my God. I feel it coming, but it's not coming. Okay. I just go ahead and let it come. And that factual scenario came up in the Wisconsin case that sorry. Sorry. That came up in the Wisconsin case that addresses in Freeman. Oh my God, y'all. I feel it again. I'm just asking I'm asking you based on, as I understand it, that would not, sorry, y'all, that would not meet your definition. So your position would be that that's not prostitution? Shapiro says, yes, I'm correct. That's correct. All right, the judge says. Then Shapiro says, the last thing I'll say is just, I know the court is aware of this. The statute that Mr. Combs has been convicted of violating is possibly the most infamous law in history. The United States, hold on a second. Can I call? Sorry, somebody was calling me. Okay, here we go. Lastly, I want to say, it's just, I know the court is aware of this, the statute that Mr. Cohn has been convicted of violating is possibly the most infamous law in the history of United States Code. It's racist and sexist origin and early enforcement are well documented and beyond dispute. And even 100 years ago, in a very different age, the statute was being criticized for multi Supreme Court justice who sought to limit it to commercial purveyors of prostitution, even in its early days, and certainly later in the 20th century. Many judges and juries refused to enforce it. We only talk about that a little bit in our brief, but it's because it's discussed at length in this book, which we cited in case anyone is interested. The whole history of the statute is really, I would submit, respectively, an embarrassment to the United States of America. Nearly 75 years ago, as we've talked about ad namus, the DOJ stopped enforcing the law in non-commercial cases and has followed the policy to this day, other than the case involving minor or sex trafficking. And under that policy, this case would never have been charged had the government not brought other charges. But it was unable to prove those charges, and the jury rejected them. So, what we're left with is a case that adults who travel interstate and participated in threesome, an adult couple that chose to have sex by bringing a third consenting adult into their private sex life, is unclear why this conduct could be criminal in 2025, even if the third person was a professional who was paid to participate. So, for those reasons, as well as all the reason in our brief in which we discussed today, we submit that Mr. Cohn should be acquitted of the two-man acts. And the judge says, all right, thank you, Miss Slavic. And here comes Miss Slavic. Yes, Your Honor. Just to respond to a couple of points that the counsel raised. First, the government is not conceding that the Mann Act implicates any sort of First Amendment rights to view porn. I think, as is made clear in our brief and argument today, our view is that the Mann Act simply does not apply here. I think that consistent with Freeman, which says that the purpose of Mann Act is quite removed from and has no direct impact on First Amendment activities. That's the first thing. The argument that the counsel makes about DOJ's policy related to the Mann Act and the history related to those that laid out in several previous submissions, there was no motion to dismiss the Mann Act, where the council raised the same issue. The court denied that. The argument related to DOJ's policy, the government response, I think, is in our bail opposition filed in July. And then finally, counsel argued that here in this case, there should be no concern about secondary effect on prostitution, including violence, including drugs. And I mentioned because all of this conduct is in this case occurred behind closed door. And Your Honor, respectively, I think that actually why the secondary effects matters so much is this case, because what was happening behind closed doors, Miss Ventura was being punched in the face, Jane was getting hit and kicked, and the defendant was providing drugs to all parties. I think it's especially important here to consider the secondary effect. Stepping back more broadly, I just want to point out the reason that we're here, which is sufficiency of the evidence motion. In other words, the defendant has the burden to show that no reasonable juror could have found that the evidence presented at trial established the elements of conviction beyond a reasonable doubt. And that simply is not a burden that the defendant can meet. Over 7 weeks, the jury heard evidence that overwhelmingly proved the defendant transported Cassie, Jane, and male escort, both domestically and internationally, so that they could engage in prostitution. Cassie and Jane both testified, although they didn't want to be having sex with strangers, they participated in hours and days long freak offs and hotel nights, sometimes on a weekly basis. And those freak offs were about one thing only: the defendant's sexual gratification. He planned them, he choreographed them, then all for one purpose, which was to suit his sexual pleasure. And each freak off follows the same general pattern, which culminated with in the escort being paid to have sex with Miss Ventura or Jane, except if the escort couldn't perform sexually, then in those cases, the escort was paid less or not at all. The defendant, sometimes with the help of Cassie, Jane, or his staff, arranged for escort to travel to these freak-offs. And this is what happened over and over and over again from 2009 to 2024. That's 15 years. The evidence implies satisfy Rule 29. That the Rule 29 standard is that any rational trier of facts fact could have found the elements of the crime beyond a reasonable doubt. And it also requires the court to view the evidence in light of most favorable to the government and to draw all inference in the favor of the government. So, Your Honor, the government's view is that the defendant cannot meet the burden here, and his motion should be denied. Thank you. While we're here, Ms. Slavic, I'll start with you. Are there any issues that the government needs to raise related to the next week's sentencing proceeding? No, Your Honor. The court, if the motion is not granted, no, Your Honor. Thank you. Ms. Shapiro, anything that the defense would like to raise? No, Your Honor. All right. So we'll see everyone. Thank you for the argument. Good, very good argument on both sides. For the papers, which were superb, the court will consider them and reserve decision on the motion. We'll get you a decision very shortly. Otherwise, we'll see everyone back next Friday. Thank you very much. We're adjourned. All right. That was it. You guys, I'll see you later. Hello? Hello? Did y'all hear me? Did y'all hear me? Did y'all hear me? I say I'll see you later. That was it. Thank you, Serena. These people come in here starting crap with me. I don't, you know what? And thank you again, Mind Chow, for the super chat. Appreciate you. At least you showed me love. Bye, y'all. Later.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars.